Me da obi bia say me sanso mo obi bia kwa basonko e de ba eye Enkasa TV so se enene de kan awhwe Enkasa TV a mesra so be subscribe oba like na wa share mema room fi so be mi odoma na so sine de bitima so benya bia hwe etie kama kasebo ana edu on ma me de besum we mi am ne kasebo iba besum ya mo so for dada ohene ba kwa amsafo kantanka me na kasebo no esi mina so am de ba besum we emre eso si another form nim say waje akonya e twensen sem ne kasebo ayen sa beka friend Enkasa TV video mu ha bia na ba besum abobo ano na so nya bi etie ahwe kama Muma enje brani enko kasebo no mu enchire mu eye obi ana oni journalist bi akom ho abom ede eye Jachie Quason ho asem bi abeto abonten abusuafo enye asem keto amekasa ya asem keto aka na me yede na meboa na ensembe na obi ni journalist ede ebeto abonten yanje bre nko tie mu nchemu bra ya ba de omi ano ba biso
Pastor John date 19th July 2023. During the cross-examination of the first prosecution witness, Richard Techiminsa, after a witness had testified confirming that he had given a statement to the police to which he attached certain documents, which testimony is also reflected in the police statement itself. The Attorney General, responding to an application by my counsel for disclosure of the attachment the witness referred to, stated that there were no attachment to the said police statement. This clearly amounted to providing testimony to the court, which I am advised and believe to be true, is clearly contrary to the rules of professional conduct by lawyers in a case. The quote testimony unquote provided by the Attorney General contradicted the testimony of his own witness and was presented for the first time without any prior notice to my lawyers or myself as to the fact known to the prosecution. Significantly, after the intervention of the Attorney General, when my counsel asked the witness whether he still stood by his testimony that he had attached documents to his plea statement, the witness would not provide an answer to the question. In effect, the testimony of the witness had been influenced by the professionally improper testimony of the Attorney General. My counsel has applied for a certified true copy of the proceedings before the trial court on that day, and I would make this available to the disciplinary committee as soon as it becomes available. There are also the following further instances of professional misconduct on the part of the Attorney General. On 16th June 2023, when my lawyer was seeking to bring to the attention of the court that I was a candidate in the then pending parliamentary by-election in the Asen North constituency, the Attorney General used the following insulting language against me. Quote, "This is what I describe as a very totally irresponsible step. Beside it, to apply to contest again when he knew that these proceedings were pending for which he can go to jail." Unquote. This gratuitous insult on the part of the Attorney General was without any basis and had no place in the trial, and I'm advised by my lawyers is contrary to the rules of professional conduct of lawyers. I attach herewith the record of proceedings before the court on 16th June 2023, during which the Attorney General made the insulting remarks I am complaining of. The Attorney General has also misconducted himself by his granting of at least one media interview in relation to my case. The Attorney General has claimed in court that his comments followed a decision of the Supreme Court in respect of an application for an interlocutory injunction restraining me from performing my duties as Member of Parliament and were not in respect of my criminal trial. It is my understanding that the rules of professional conduct do not allow lawyers to grant media interviews in respect of cases they are handling. Thus, whether the media interview of the AG was in respect of the civil case in the Supreme Court or in respect of the criminal trial, the grant of such an interview was contrary to the rules of professional conduct for lawyers. In reality, the said media interview, in its terms and at a time when the AG had initiated criminal proceedings against me, was clearly understood by the public as being in respect of the outcome of the criminal trial also, and was clearly prejudicial to me. I attach herewith a report in the media of the prejudicial remarks of the AG. Through his professional misconduct, the AG has clearly jeopardized my fundamental human right to be presumed innocent until I am proved guilty, and my trial and my right to a fair trial. I therefore respectfully request disciplinary proceedings against the Attorney General for professional misconduct as outlined above. Yours sincerely, James Jachie Quason, MP, Asin North constituency. This whole Jachie Quason sense from Central Region and the demand BPA Court of Appeal, Supreme Court. As we speak, Supreme Court, the civil now has been dealt with. Criminal partner Koso. And I think in the criminal trial, no, one instance that just say, "Oh, see, AG can be there."
And it actually came up in court. So we share this letter to the GLC now. In two folds. One, alleged prejudicial comments by the AG, and the second one, the fact that AG was handling the matter and was granting media interviews, and which he feels that it's against the media,
the professional conduct of lawyers.
So when the matter came up, there were two. The president voice at Asan North during the rally was played. I think a bit of it under 2 minutes was played. And then there was an objection by the AG indicating that if they will play the voice, then they should situate it within a proper context. And so the entire 13 or 15 minutes of it should be played in court. In fact, that matter ended. And then it wasn't only the AG that was cited for some prejudicial comment, but the president as well. So now what I see him doing is to go a step further. In fact, the judge ruled that it did not in any way affect the current case that was ongoing at that particular time.
For president, the voice, no?
Any
age.
Exactly. So it was raised. I mean,
it
was raised.
The trial judge no ruling.
Exactly. So it was tendered in evidence actually. So that's what I was telling you, that the voice of the president
was tendered in evidence.
Yes.
And it was played.
It was played.
And the judge gave a ruling on that.
Yes. So the judge
the case.
Exactly. And so that one, I mean, came to nothing at that point in time. So we know, I see, say they are taking it to a step further to professionally situate it. Exactly. So, number two, and we've heard it says, "Oh, your case, you don't have to grant interviews." It's the case, is related to you, and as a one handle case now, you don't have to grant it.
But was that issue also raised in court by lawyers?
No, so I'm hearing
the bit about the interview.
Yes, the bit about the interview is now news. But the prejudicial comments, I think it's come out before. Yes.
Okay, let's see. GLC, interestingly, the AG himself is part of the GLC, General Legal Council. I think AG in appointment, the AG was some reps are no appointee onto the GLC apart from himself. President were reps, some of the law faculties no reps. So the Chief Justice himself is the chair of GLC. Let's see how that would pan out. Very interesting.
But case in here, very, very interesting. So now there is a bit of reprieve following the adjournment of the case to October when they are back from the legal vacation. And so because it's still a long winding road.
Very, very long.